Hey guys, and welcome to today's video. Today, we have a continuation from our legal expert in our last video where he tries to file his power of attorney with the solicitor's office and he can't understand why they won't accept it. Now before we begin, I want to point out a few things as I've done some additional research into this case. The person in custody is Patrick King. He was arrested for possession of an illegal substance by an unlawful alien. It makes you wonder if this guy fell trap to the American State National Movement, which encourages people to renounce their American citizenship, turning a simple possession charge into a very serious deportation case. Now this is the last video of 2022, so let's begin.
Hi, is this Marcus?
Yes.
Hi, my name's Rachel. I'm calling from the solicitor's office. I got your voicemail in regard to Patrick Raymond King.
Oh, I'm here right. I think I'm at this. I think I'm at the solicitor's office.
Okay. Yeah, I was just calling to tell you that the hearing that's tomorrow is not anything you need to worry about. It's
Okay.
because this is a criminal case, so it's
Okay.
not something a power of attorney is really relevant for.
Okay. Well, he doesn't have any representation other than the power of attorney. So I just wanted to bring the power of attorney bring it to the solicitors to have it recorded.
Okay, well, I mean, if you're not, like, an attorney that's representing him, there's, like, it's not really, you know, like, people who aren't attorneys, even if they have power of attorney, can't represent someone in a criminal matter.
Yeah, because I'm not representing him. I'm just an extension of him, and he's let me know what to do.
So you're representing him, like what a lawyer would do for his client in judicial matters. And another thing, you said the only representation he has is with that power of attorney, which isn't true, because unless he turns down or doesn't qualify for the services of the public defender's office, he's guaranteed representation.
Right, well,
I mean, as far as the maxims of law, I mean, there's not a state license to practice law, so it's not like I can go to the state and get an actual license. I mean, the best I could get is like a bar membership, which is a PMA. It's a private member association. I'm already with one of those as far as a PMA.
Nobody cares that you belong to a private paint tasting club. It still doesn't change the fact that you need a license to practice law in the state of South Carolina.
But you don't, I mean,
right.
You don't know about...
If he doesn't have a lawyer, he'll get one appointed to him. So it's not something that a power of attorney would take care of.
Are you an attorney?
Yes, I'm the solicitor on this case. So I'm the one prosecuting this case.
Okay, all right. What is your name?
My name is Rachel.
Okay.
DeAngelis.
Okay.
Yeah, I mean, this is something. So what this is if he doesn't have an attorney, they'll.
I'm sorry. Go ahead. But he wanted me to enter the power of attorney with the solicitor's office, so it's on record.
Okay. Well, I got your voicemail, and I have that he has the power of attorney. But again, that's not really.
Yeah, I have the document here to enter.
Okay. We don't really we don't deal with power of attorneys. Like, I'm not sure. I'm not 100% sure what you think the document would do for us.
Oh, okay. So you're the solicitor. So then I should send the writ of discovery to you for him?
No, you shouldn't be sending in any writs or doing anything that an actual attorney would be doing for his clients, unless you want to be charged with felony practicing law without a license.
Because I sent the office of written discovery, and they're telling me that they called the attorney in the case. I said, well, who's the attorney in the case? They couldn't tell me who it is. I don't understand what that deal is. But they said there was no attorney entered for appearance for the affiant. So then they told me to call the solicitor's office. There was a writ of discovery sent to them. Go ahead.
So the affiant that you mentioned, Zachary Lepori, he's a police officer is the one in charge of this case. So he doesn't have a lawyer. He's the police officer. It's not a civil matter. It's a criminal matter. So it's just between the state and the state.
Right. So what made it criminal? What made it criminal?
mean,
a traffic infraction is not a criminal.
You can look up. You can look him up.
Yeah, you're talking about statutes and codes, though. I'm talking about the probable cause to pull him over in a criminal matter. I mean, was he under investigation? Because it looked like maybe they knew who he was, and they were saying something about another matter with ICE or something.
I pointed this out in my last video. ICE is not an agency that you want to be messing with, especially since they're the ones that can deport your ass out of the country. I can't stress this enough. Stop playing house with your friend's life and get him an actual attorney.
Sir, I can't really discuss the case with you. You're not his attorney.
Well, you're right. That's why you gave me a power of attorney. So I'm going to enter it in the solicitor record that I'm power of attorney. So basically, any attorney that he would hire, we would all consult.
Okay, he does not hire an attorney through us. We do not represent people.
You would need but you're the solicitor.
Find an attorney.
I mean, right here, the non-lawyer maxim. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. See NAACP versus Burton, 371 U.S. No state shall convert a liberty into license, charge a fee for it. Murdoch versus Pennsylvania. The practice of law cannot be licensed by any state. See swearing board examiners. I don't understand why I can't have there's plenty of non-lawyer maxims.
And as long as you keep misinterpreting those maxims, you're going to keep finding yourself on the short end of an already short stick. The NAACP versus Button, not Burton, was about an unconstitutional law that Virginia passed, which was essentially designed to prevent civil rights groups from seeking out and litigating on behalf of potential clients. But the NAACP wasn't sending some random jackass who failed 3rd grade all the way through his 30s. They were sending actual licensed attorneys. Murdoch v. Pennsylvania was about forcing a religious organization to get a license to sell their religious material, which was found to be unconstitutional and has absolutely nothing to do with the right to litigation. And Schwar v. Board of Examiners was about the bar being prejudicial towards someone who would normally qualify for obtaining a law license. Now, you might actually have an argument here if you actually qualified to be an attorney. But unfortunately for you, the only thing you've ever qualified for in life is to be a sommelier of liquid crayons.
Assisting him with his defense, that would be with his attorney. We are not his attorney. He would need to get an attorney, or he can get one appointed to him through the state.
So for now, I'm entering power of attorney.
That's something you and him need to take care of.
Right, that's why I have power of attorney. So then I'm going to enter that on the solicitor's record. So for now, I have power of attorney to be able to talk to whoever attorney that would be that he would hire.
Okay, yes, but we don't have, we have no control. You have to talk to his attorney.
Yeah, but right now, I'm assuming that you guys presume and assume that you have power of attorney, and that's why you think that you can appoint counsel to him regardless of who he wants.
Wrong again, dipshit. The prosecutor's office does not appoint the public defender's office to the defendant. That order comes from the court. Nor do they assume that they have power of attorney over the defendants, nor do they have as much of a problem as you're having understanding exactly what a power of attorney is.
We do not think we have power of attorney over him. We don't have anything to do. Well, we're just prosecuting the case.
So then how would you appoint counsel tomorrow if he doesn't have it?
We don't appoint counsel. The solicitor's office does not appoint counsel.
Okay. All right. So
you do not handle anything. It's not us.
Okay.
We don't appoint that.
Right. So basically the judge would demand or order him to hire the county's public defender's office, right?
Well, no, he wouldn't hire the public defender's office.
He would get appointed the public defender. But the only way a judge could do that against his will is if they have power of attorney over his principal.
That's so wrong. It's not even wrong. You have the right to an attorney at any criminal trial. Whether you choose to use one or not is up to you. A judge can only force you to use the public defender's office if he finds you both indigent and incompetent to defend yourself. And even if he does find you competent, he can still appoint you standby counsel just in case you need it.
Well, he doesn't have to get appointed an attorney. That's an option that he has.
Okay, is he going to be brought to court tomorrow? Because he's in an ICE facility.
I would believe ICE would have to take care of it, or they would have to figure out a way for him to end up with an attorney. Yeah.
And no. I'm sorry. I switched subjects. As far as him coming to court tomorrow, because it says he has a court hearing tomorrow, he's in an ICE facility, and they don't bring him, then they might try to give him a warrant for non-appearance.
If he's in an ICE facility, we would not get a warrant against him, or if we did, we would dismiss it. We understand that someone who is in an ICE hold cannot get to court unless they're brought there.
Okay, so as of right now, they wouldn't be able to push a public defender on him, say he didn't want to get one. They wouldn't be able to push any type of attorney or public defender on him through the whole duration of the case?
I mean, if he's not looking to get an attorney, then no.
Okay, so he wouldn't, if he didn't want to hire, or let's say he didn't want to apply for a public defender, he wouldn't get held in contempt for that, right?
Well, technically that depends. If the judge finds him incompetent and orders him to use the public defender's office and he refuses, then yes, he can be held in contempt. But the simple act of not applying for a public defender is not a contemptible action.
I'm going to be honest, I don't really deal with that. I'm not 100% sure what the process is.
No, that's never happened before in court?
Not that I know of. It has not happened. I mean, I'm sure it probably has. I don't know. I don't know.
Okay. So am I allowed to enter the I mean, I should be able to record this with the solicitor that I have power of attorney right now.
We don't have anything to do with like him or his defense. You wouldn't give anything to us.
So is there like a county recorder's office that I should record it at?
I'm not. I have no idea what you would do with your power of attorney. If he gets an attorney and he doesn't want one, like you could file it with them so you can talk to them. But we don't deal with anything about a defendant getting an attorney.
Well, I sent it to the officers, and he's basically trying to be able to talk to the prosecutor, be able to talk to the officers to give me power of attorney. And they're basically saying that the only way that he can do anything is he moves pro se. Well, he doesn't need a temporary bar card to move pro se or defend any type of trust if the state is responsible for the public debt. And the state's a trustee and they're liable unless he's going to be in a surety position, which I assume that he's in a surety position, right? Isn't that what the bail bond is about?
If only bullshit and word salad could feed all the hungry children in this world, this jackass would be a fucking saint.
Does he have a bail bond? The sheriff's department told me that it was a reconnaissance bond, but they're telling him that he has a $5,000 bond, but then they're saying, ICE is saying that they have a bond, but then the county sheriffs are saying...
ICE is separate. He's not in an ICE hold because it's like ICE is a separate issue. That would have to do with his immigration status, which could be affected by this. Like,
right, but that's a separate bond from the criminal case, I presume, right? Like he would have a bond for the criminal case and then a bond for ICE, correct?
I believe so, correct.
Does he have? I mean, I know he has one bond, the $5,000. Is that for the criminal case or is that for the ICE case? Because that's what we can't figure out.
I have no idea what ICE would have on him. That ICE does not talk to us about stuff like that.
He was told that there was an ICE bond for like $5,000. He originally was told that it was a criminal bond for this criminal case. So he's under the impression that he has a $5,000 criminal bond. But then his girlfriend saying that she was told it was an ICE bond.
Something that I would need to talk to an attorney about. You are not his attorney, even if you have the power of attorney. So I cannot
that's not even how it works though.
Maybe that's not how it works in the land of make-believe, but in reality, where the rest of us reside, that's exactly how it works. They aren't allowed to divulge any personal information or information about the case to anyone but him or his attorney. And I would think that you, as his friend, would appreciate the court respecting his rights to privacy. Now, as far as bond goes for your bestie, maybe you didn't get the memo, but Mr. King is currently on vacation without bond in an ICE facility in Georgia.
He gave me power of attorney to handle the affairs or everything, and you're trying to tell me that regardless of his power of attorney, you can't talk to me because you need to talk to what? A bar attorney?
I would need to talk to whoever is representing him.
Right now, I have power of attorney. I'm representing him right now. I have power of attorney.
You are not representing. You cannot represent somebody in a criminal matter if you're not an attorney.
I have 6 lawyer maxims right here, non-lawyer maxims that say otherwise.
I assure you, somebody who is not an attorney cannot represent.
Litigants can be assisted by unlicensed laymen during judicial proceedings. See Brotherman of Trayman versus Virginia.
Yes, an attorney can be assisted.
Litigants can be assisted by unlicensed laymen during judicial proceedings. It didn't say anything about attorney. It said unlicensed laymen. The practice of law cannot be licensed by any state. Schwer versus Board of Examiners. Members of groups who are competent non-lawyers can assist other members of groups achieve the goals of the group in court without being charged with unauthorized practice of law. See NAACP. The NAACP, they even ruled on it for that. So how are you going to tell me that?
They're gonna tell you that for the same reasons I already told you, because you're completely clueless as to the role of the NAACP in that particular Supreme Court case. Same thing goes with all your other maxims that you cite. You don't understand them, you misrepresent them, and then you twist them in such a way that only an idiot would understand. You are that idiot. Alright guys, that's where we're gonna end the video today. If anything more develops in this story, I'll be sure to let you guys know. If you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.